Snow fell cold on a bitter night. John was gone for the morning light. They blame Karen, but it don't sit right. Too many secrets hid from sight. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town. Proctor's story shifts and sways. Cameras vanish, records fade. The Alberts toast while the doubts grow strong. The folks still fight, won't be long. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town. Proctor's story shifts and sways. Cameras vanish, records fade. The Alberts toast while the doubts grow strong. The folks still fight, won't be long. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town.
Hey everyone, and welcome back to what you ladies have been pining for a year. 1 year of the Crash Daddies.
Yes.
Disclaimer, this channel won't be covering any water damage that will be incurred during the testimony.
We will try to control ourselves, Baker.
Hey, Nina Canadian. Thank you, Camber. I had a good day that day. Good evening, Amanda. What? Don't know. This morning, what, if anything, did we learn today, Mo? You are the Czech illiterate jury member. So right now, how sure are you that John O'Keefe was killed by Karen Reed by striking him with a car after listening to roughly 3.5 hours of expert testimony by the Commonwealth?
Well, I wrote 5 pages of notes, and I don't understand anything any clearer than I did before, because it seems like there's a lot of variables in every bit of very accurate information that he has. And I'm confused as to how you could come to a concrete theory with so many variables that you want me to sort of take just on faith. And I don't trust phones, so I'm just confused.
What I gathered was all of this was his opinion. None of it was really provable, because his testing of driving around with his phone in his hand, it's kind of like the Murdoch trial. Where is the photographic evidence? Where is the neutral observer that said, yeah, I checked his phone. When he got into the car, it said 0 stairs climbed. And then we rode around for 45 minutes, and it said he'd ran a marathon and crawled up the Empire State Building. How do you verify his finding. This is why you have experts. And again, before all of the smart people on the other side says, this is the guy. This guy has exactly the same education that Trooper Guarino has. He has a 3-week course in how to read Cellbrite data. He's the same guy who works for Cellbrite as a sales rep. He's the go-between between the nerds and the customers. He's a project manager. This is what he does. Then he has a stupid blog and a program that's downloaded by tens of people. And he claims that he has special knowledge about Cellbrite. He doesn't know anything else than Trooper Guarino on paper. Yes, he's worked for them for years. He's talked to their cats. Fine. But he has no specialist knowledge in anything he testified to today. Nothing.
Now, you and Valhalla remember the last trial. Did he bring in
Yes.
the health data as far as the steps and the location data last time?
They did the location. They did the step. Oh, I forgot to share the screen. They did do the how many steps and stuff like that. But that's when their timeline was, she hit him at 12:45. And now their timeline is she hit him at 12:32. But the last trial, it was unequivocally proven that she must have left Fairview 32 at 12:30. Because she needs to be at John's house at 12:36 to connect to the Wi-Fi. She needs to be walking through the garage at 12:41 because you can hear her heels clicking on the floor, yelling at John on the phone. So why go with a busted timeline to begin with? This is the big problem for me, especially when he said, so after the phone stopped moving, there was no more motion. And then he says, well, except 36 steps. John was instantly incapacitated.
Also, I sort of understand what he's saying about the phone getting, like your steps or your stair movement after you stop moving. But then you need to show me exactly when he started those steps.
Yeah.
I guess, and why the phone wouldn't pick up this being moved back at, 15 miles per hour or however many miles per hour, Karen bumped into him. That doesn't register on the phone as a possible drop or a fall?
Again, I don't have Apple because I like phones that's a little more modern. But apparently, if you just have an Apple Watch, and I know I can actually have my stupid, it's a Samsung. If I fall over, I can make it call 911. There's an accelerometer in this watch that will tell, oh, something happened. I'm going to ask him if he's okay, or I need to call 911. So I have to actually, if I put it on, I will have to actively go in and say, no, I'm fine. I think it's the same with Apple. This guy is getting hit by 6,000 pounds at 24.3 miles per hour. Sending him flying, it would be an extreme acceleration in a very short time. Even if he just spun around and started tilting, there would be, let's just say he spun around and then he fell over. There would be, I don't know, do they try and say this is the 36 steps is when he's doing the pirouette? I don't know. That's actually default setting, the crash fall setting. You have to turn it off. I have turned it off.
Oh.
I looked it up. 2022 Apple phone didn't detect the fall, but the Apple Gen 2 Watch did. Thank you. Someone who worked in a club took my wallet and phone off a table, and I could see my phone moving, stopping. Big charge, walk again.
Huh.
Stop, more charges. Has to mean something, not enough to just maybe exist some of the time. How much distance did he cover? He walked, was it 18 meters with the 30? No, how much with the 36
For
step?
some reason, 85 feet is coming to me, but that might have been
Yeah,
linked
that
to
was
something
earlier.
else.
That's the time where he was in the car, even though it registered he walked towards the house for 85 steps.
Right.
Yes, Palolas, I said this morning there will be a quiz. If you're not ready for it, you won't pass. You will have to go back, rewatch all of this morning's testimony, and write a 500-word dissertation on
Oh,
the
that's
internal
mean.
clocks and why Unix time isn't the same as whatever else time he said. I forgot what he said.
Well, eunuch time lacks balls.
What time did they say the 36 steps happened? They didn't really. They said it happened after the phone locked for the last time.
Yeah, somewhere
part that-
around.
There's
Somewhere.
a bunch of this that is bugging me, right? He said he contradicts himself all over the place. All the information about the clocks was completely useless. There was no reason to give any of that to the jury.
No.
You could have just summed it up in like a 2-second thing, right? It's going to be the right time, but it's going to be 14 days later or before, or whatever it is. The other thing with the
Explain it like you
flights of
explained it.
stairs-
I would have understood.
Well, but he did that intentionally, though. That's the thing,
Yeah,
right?
yeah,
Like
they
he
didn't
had
want
to
them
have been
to
doing that
understand.
intentionally. Exactly.
Well, yeah.
Exactly.
Yeah.
And the other thing with the flights of stairs, he contradicted himself there too. He said that you had to change 3 meters, which is essentially 10 feet. No reason to not say 10 feet other than to make it seem like a smaller distance, right? And he has to do it within 16 steps. Well, I can't imagine that those rules would apply differently just because he's in a car. Some of those things that he was attributing to the descent of stair flight were way longer than 16 steps and shouldn't have in any way been registered by the phone.
No, and again, if he did within, this is 20 seconds, walked 84 feet. That's a lot.
Unmuted.
And opened his face with his Face ID, meaning that his face couldn't have been jacked up at the time.
Yeah.
This was, again, it was only to confuse everyone.
It really was. And I think they actually proved that he was alive much longer than they can have Karen
That's why I
respond.
say they fucked up their
So we
timeline
know
again.
that the
They really did.
Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with
Repeated
reciprocal
motions.
discovery regarding the ARCCA witnesses.
The expert was in United States. He works for Celebrite. I think he works in America, but he also have a website in Switzerland.
He was saying that
Previously,
he
about
was
a month
doing
or
the
so
testing
ago,
in
maybe
Calgary.
longer, I found that there was a
He mentioned
violation
something about
of
being in
the
Calgary.
defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCCA witnesses or to exclude their testimonies. Upon that, I believe, I issued an order last week for certain discovery to be provided and to be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that,
Did you say there was another violation? She didn't say that the other day. She said she needed them there, and that's why we haven't the voir dire. She didn't determine that there was a violation at that point.
So now she's counting 2 violations. If I'm
Yeah.
okay.
It's half day for the jury. That's why the jury is let out.
especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So Mr. Brennan, who are we going with first? Dr. Wolf?
Have your biases
Okay.
showing. That's funny.
Gonna face the clerk and raise your right hand.
Solemnly swear that the testimony you shall
Crash
give in
Daddy.
this court and the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Can I-
All right, go right ahead, Mr.
Thank you.
Brennan.
Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So we
order?
need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolfe, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Miss Little last year, I was under T-Mobile was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get
I
any
see what he's
records
doing.
prior to
I see what he's
or
doing.
at least from my T-Mobile carrier. Then I went through my Verizon records.
It's
that I
normal to
have
switch
from
phones.
2025.
It's
I
normal
could
to not
only
have
Only
your
if
months
you're
provided those
if you're
records.
getting
How about
subpoenaed.
emails? You didn't change email
Yeah.
carriers, did you?
No,
yeah,
sir.
Did you
that's what
provide
he's
all your
doing.
emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably
Yes, it was only a half day. This is voir dire of the Crash Daddies.
6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time, who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson
Yes, sir.
a number of times.
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Ms. Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please. Thank you.
He's such an ass.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on the
Yes.
defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have?
Why does he think that he would?
Because
sure.
he wants them to slip up so he can claim she waived privilege.
Sure, but like, why does he think that that would even have happened? Like that's a weird approach with how serious ARCCA is and the Justice Department being involved. Like, you think Karen Reed's going to be on one of those emails? Come on, man, get real.
Well, this is all he has. He needs these guys gone. And again, as Brendan says, he's forcing him to answer, so it sounds sketchy. And again, this is all performance. I will bet you Bev already have her order completed, so she can. I think my best guess is she will order that they can testify in the same order or in the same way they did in the first trial. They are not allowed to mention the feds, and they won't be allowed to debunk the Commonwealth's witness. I really hope that Alessi kicks that.
There's no
behind.
way, man.
How many
There's no way.
that weren't on a regular telephone?
We've been doing this for 2 years. There's a lot of ways.
You have a Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
There was a federal no
I don't
contact
believe so, no.
order.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
He just did.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided
You're not going
or
to
you learned
shake
you may
this
be
guy.
part of this case
You know what I
as
mean?
far as
Like,
a
he's not going to
witness.
get rattled.
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk?
You're such,
What a
you're
cahoon.
such a little bitch. There's no jury here today. Judge Bev, you should step in right now and say you don't have to perform for the jury that's not here.
Did you see his face?
Yeah. He's doing exactly the same thing he did with Alessi. Instantly made him dislike him. Alessi was going so far to try and be on his good side. And he just
that
shat
didn't
all
last
over
super
him.
long. Yeah, it didn't last very long.
Yeah.
Brennan's such an
Talk
ass,
about
you
more
guys.
than logistics.
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
That a
Thank you.
boy.
So as I
That a
mentioned,
boy.
again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling?
Because if
Because
they
it was
were
gonna do a
hired to
job,
do a
you
job, they
numpty.
need to tell the lawyer, we're costing $1,000 an hour. Oh, we don't have the budget for that. Okay, we don't have anything else to talk about. This is kind of
dumb.
like hanky-panky. When you talked to Meatball Morrissey and you said, I'm going to need 80,000 to do this job. And he said, yeah, I'll give you 230,000. Well, I'll take that. I hate this guy.
I really do. I can't stand him.
He is such a jerk face.
And being paid at that point.
Objection, Your Honor.
I'm going to allow it.
Again, because
course
Mr.
you are.
Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process when a client reaches out and wants to engage us for trial testimony. That's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
Details, no.
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is
In
a
your
difference
mind.
because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a
Special Prosecutor Brennan is making our joy with the argument all FO. I'm sorry, Francis' mom, but yeah, they will shine a bit later.
client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client. I'm talking about this client. Did you
Oh my
talk
God,
about
this
them
man.
potentially
He's
hiring
an
or
idiot.
retaining you for
He-
work in this case? That's
he
the
wants
question
that
I'm asking
line.
you on March
That's what he
20th,
wants.
2022, not the 22nd, not the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I
He's an
spoke to
idiot.
him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States
Eat
Attorney's
a dick,
Office.
Brennan. Eat
And
a
you
dick.
wrote an email back saying that you were going to put
God.
the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and
Relationship.
anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed. And I had let him know that I had spoken to the DOJ and got clarification on moving forward.
So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an
Outstanding.
advocate for the defense?
Sustained.
When we proved
Do you
she
feel
didn't
like
do
you're an
it,
advocate for the defense?
When did you become an advocate for the defense? Oh, so you're highly biased
What?
and
It's like, when did you stop laying hands on your wife? There is no way to answer that question. And Brennan is such a douche canoe. He is every single, stereotype of a sleazy, corrupt, smugly lawyer. Ugh.
I can't stand him.
He's gonna make Crash Daddy lose more of his glorious hair. Look at
No,
how
he's not.
thin it's gotten.
He's not phasing Crash Daddy. Some little peon defense attorney hired in as a special prosecutor.
it.
Dr. Wolf don't give a damn about his little weird haircut.
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United
Could you imagine if that was Jackson? She would have been all over Jackson in his comments.
Yeah.
Oh,
Wolf is too smart for this. This is fantastic.
he's not going to.
Brennan should be held in contempt of the bar or something.
States
He's
Attorney's
in contempt
Office
of good
gave
taste.
permission for you to be called as a witness. You called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had
At least
permission
some
to
records.
use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualification.
Thank you, Jess.
Now
for
they
the
have a
contribution
personal
to the thread there.
relationship. My bad. Sorry.
Yeah, and that's why you lied for him, because you talked about your kids.
That's going
How much else did he make you lie for? Did you get money under the table to be a lying liar?
Oh, I hate Brennan. I hate him so much.
This is why I said he seems like a scumbag defense lawyer that'll bend every rule, and that's not the rule of the prosecutor.
Well, it
We're still
seems
back
to
in
be.
April. You're moving ahead to May when you first started going. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes, specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that
Improper relationships between the defense and ARCCA.
that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson according to
No, he wasn't. He already had.
Was he
the
trying to get
You
to
don't
third
remember the early
base?
conversations with them and what they were about?
Yeah,
I'm sorry, are we talking about now at the end of April still?
because there's a bill that they paid for the time they spent in court, and because Bev is an idiot.
Still talking at April.
Mostly
April
because Ben's an
24,
idiot.
2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Yeah.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
He's
To the
already
ARCCA main line.
main-
Let me guess. Hey,
That's a
I want to speak
receptionist.
to Dr. Wolf. Okay, I'll check if he's ready. Dun, 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 dun. Hey, Mr. Jackson, you still there? He wasn't at his office, but I'll try and transfer you. Hey, ARCCA main line, tech division. Yeah, I want to talk to Mr. Wolf. Yeah, I think he's out back shooting his chicken cannon. hold for a minute. Bum, 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 ba-dum,
Bum,
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 ba-dum,
bum,
ba-dum,
ba-da-da. And then it cuts in. You are important to us. Please hold on to the line. We are getting your call at the very same time that, well, we don't care. So just stay on there.
bum, ba-da-da-da, bum, bum. All calls might be recorded for use in educating our workers. Press star if you want to participate. You press star. We might call you back. Dum, da, 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 dum, 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 da, dum.
Oh my God. He is such. Has this man had access to my doll? Because Brennan is sounding like a teenager who got told they couldn't get that Limp Bizkit t-shirt from Hot Topic.
The worst part, though, is that Bev seems to be siding with him.
Of course
Right,
she
like-
is.
Right. Like how
Yeah.
I don't understand how she can make that leap. You're supposed to
Because she's biased, Bev. She's
Well,
just
I
been
guess
looking
that
for
would
it.
do it. I guess that would do
Since they're now hired, aren't their communications work privileged private stuff now? No, they have to turn over communications between the experts and any product that they have for court. It's a part of Rule 14 discovery.
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall from a year ago.
When I ask you to guess, I'm asking for your testimony.
That's what I.
Objection, Your Honor. At least
Is
treat
there
the
a
witness with a little bit
Cahoon
of respect.
objection? Is there a Dick objection? Because I think he earned Dick of the Day.
Yeah. Remember when
Every
she
day.
said, Mr. Jackson, you don't have to do the performative. The jury isn't in the room.
Yep.
She should
Yeah.
give him that
Hmm.
I
instruction.
recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
She wouldn't do that to her boy
He very
Brennan.
well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary.
No, he absolutely. This is like this discussing with Plevin. Turn it back. Turn it back. He actually just said it sounds like he might have called the main line and talked to a secretary or my project manager. Why the fuck isn't Bev saying, move on? You asked this question.
She's so ridiculous, man.
Secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024? Do you remember those two phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Okay. Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations?
Do I hear a
about
train
it
or am I having a
with the
stroke?
defense?
No, sir.
So in that 40-minute conversation, you talked about your family.
It
your
might be
past
closer to a
times, ARCCA,
stroke.
but
I don't
never,
hear
ever talked
anything.
about this case.
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old
Got 'em.
invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes, I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can you approach, please?
Who asked me that?
Me, Your Honor.
Yes.
Come on over.
This is ridiculous.
Is Bev so pissed off that they have to have this hearing that she's just going to let Brennan do whatever?
Yeah. It's par for the course around here. I don't know if you know this or not, Mo, but this is how things usually go in Bev's court.
Well, yeah, but usually she is not so blatant about it. I mean, again, these are things that if Jackson or Yannetti had started doing these little asides, these little commentary, she would have been all over them. Yeah.
And she has been in the past for less than hostile acts, in my opinion. The entire town of Canton hates ARCCA? That seems ridiculous.
But it takes away his answer right there takes away any personal gain. I mean, if I'm Bev and I'm, say, trying to be all, unbiased, the fact that the invoice came from ARCCA and not Dr. Wolf and Dr. Ramadi, something with an R, that kind of that shows me that this is an ARCCA thing. So again, Brennan is asserting that ARCCA is involved in all sorts of underhanded shenanigans with the defense because now they're besties. Now,
Which is ridiculous.
Why ARCCA hasn't sent in a legal person to explain, hey, we monitor our people's phones, we do this, everything has to come through us, because this is now putting ARCCA's, credibility into, question. And that's a big thing when you are a scientific testing organization.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forward it so that could be billed?
Thank you, Sue.
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Okay. Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families.
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
I knew that.
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background?
Yes.
Certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
Mm-hmm. And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either I think Alan contacted me, letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean
Rentschler.
Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
A dick.
Probably Mr.
asshole.
Brennan.
So remember the
Probably
next time you
Mr.
spoke to
Brennan.
Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or
that's
anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing,
Hundreds, I think he claimed.
do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling, no, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual record or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all the contact.
Remember in Good Morning Vietnam, when Robbie Williams told the guy, "You are in more dire need of a BJ than any white man in history." This applies to Hank as well. Lefty, you're often wrong, but you're right.
He nailed that one. Sue sent me a super chat a little while ago.
Oh, sorry.
No worries. Swear jar for you because Baker will keep cussing. Thank you, Sue. I appreciate you. Wanted to make sure
Well,
we
the
got
sheriff-
credit to Sue.
I don't put
So-
money in this word, yeah.
I know I'm not a lawyer, but could the court have asked for a Celebrite download of their phone? Could they have subpoenaed that? Because if he was just told to give out the communications that he had, it doesn't seem like he did anything wrong not bringing a full extraction.
Well, I think they would then have to go a way different route to produce that.
Yeah, they
Because,
wouldn't be able to get his whole phone. That's crazy.
Yeah.
Well, I mean,
And he
I
doesn't
don't
have
know.
the
It
phone.
just, yeah, that's what I don't get. What I mean,
He
Remember,
printed out
everything is fine if you trash your phone magically the day before there's a subpoena to keep it.
magically.
Magically. You just feel, oh, today is the day I'm going to change my phone. Oh, I got a subpoena the day after. Imagine that happening. The luck of the Irish. That's okay. There's nothing weird in trashing your phone, driving to an Air Force base, throwing it in the trash. But this guy changing his phone number, come on now. Have you searched for text messages? Yes. Did you find any? No. Are you sure? Yes. Think about it. He just did. Brennan should be kicked in the behind.
I can't stand him.
Between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the
No,
text.
you didn't tell me, but you just did now. Thank you.
He just did.
He absolutely
you fucking
did.
Idiot.
holy
my
crap,
God.
I'm 80. That's it. Brennan, or let's go. I'm gonna need
Can
you
we
to
just skip
fill up
2
that
hours
swear
ahead
jar.
so we can swear constantly without getting demonetized?
Yes, please.
I have my auto delete set to under 30 days, no iCloud backup. Try and arrest and proposition me in jail, Brennan. Yeah, and Meatball Morrissey has a 30-day delete. Not a problem.
Also, is there a professional rules of conduct for the ARCCA guy? Because as far as I'm aware, it was a year after the last trial had finished. Are there professional conduct rules for ARCCA? Because Jesus, Mary and Joseph.
We did call out Bev. She should get her court in order. She should take this pompous B word And Morrissey should walk in and say, hey, I'm paying you $300,000 to do this crap show. You better get in order, because if these guys are allowed, they're going to tear our case apart because you got them angry.
Thank you.
Objection, Your Honor.
So next question, no
Okay.
comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent,
No, not just what you sent. Either way, back and forth.
probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember sitting down
Are we going to ask
and
Higgins
deciding
this?
intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you
Sir,
were?
I just said I delete text routinely. You're asking me to specifically give you a location at a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Well, it does matter because Bev will claim this is Rule 14 violations.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, encrypted app, isn't it?
What's that?
Encrypted?
So now it's a consciousness of guilt that you use Signal to communicate. Wasn't there something about, I think I've heard more than once that politicians on both sides in the Senate use Signal app. I think I heard highly placed functionaries, what do you call it? People who work for the government use Signal app. So everyone who uses Signal app right now is a drug dealer.
Can confirm, yes.
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal
The only time.
in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
He
I don't know
just
that
said
there's a standard out there, sir.
I'm asking about your standard. Is it your standard?
Unbelievable.
again, I
I'm
know they're
asking
not
about your
allowed to
standard.
comment, but objection, Your Honor. He's clearly misstating what the witness is saying. He clearly said it was Mr. Jackson who recommended it as his preferred way of.
Yes.
I hate this guy.
Listen. You have to listen. That's why God gave you 2 ears and 1 mouth hole, you pie hole.
Yeah, it's not some esoteric messaging app. It's out there. It's open. I use WhatsApp. WhatsApp is one of those phones where it's really hard to use Cellbrite to download them. I use it with my sister. And to this date, it's only a few crimes that we have committed after planning them on WhatsApp. And none of them would, well, a few of them would be probably raised up to the level of felonies, but only a few.
Well, that's
Standard
good.
to use an encrypted app when you're talking to attorneys.
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I
He just said it was the first time, you fucking idiot. No more swear jar fund. It's now the Baker's Coffin Fund because he's going to have a heart attack before this is over. I might actually have a heart attack. Fuck, he's an idiot. This is more stupider than when Lally asked him. It's not that I want ARCCA off the case, but I just want a fair trial. Have you ever used Signal? Do you know drug dealers use Signal and terrorists? Are you a terrorist?
This is
just
so
mentioned it was
Yeah.
the first time.
How many conversations did you think you had with the defense team by signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know.
I don't want you
How
to
many
think.
times did you use signal with the defense to talk about this case?
Objection, Your Honor.
Going to allow it.
From what I recall,
course
it's probably
she is.
a handful of times.
When you say if what you recall, are you purposely being
You just asked to give him his memory, and then he gives it, and then you said it's wrong. What the fuck's going on, and why the hell isn't Bev stepping in?
vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right. I'm telling you that I
Jesus,
didn't keep track of
Mary
it, so I
and
don't know the specific number.
How many times do you think you talked by signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means. I don't
Probably
know what that
around,
means.
probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on signal? The 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
You're
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times are between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you
Say
my best
5
estimate.
minutes,
I'm asking
one
how
more
confident you are.
again.
Objection, Your Honor.
You answer that. How confident are you, Dr. Wolf?
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to your honor, you knew that one of the important things you need to respond to were communications between you and the defense for her honor to consider, right?
Yes,
And signal is a communication, isn't it?
certainly.
You looked at all your records and knew it listed the text messages and the phone calls. You knew that, right?
Yes,
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record.
Signal
of it.
was
I
a
have no
phone
way of
call
being able
and a
to tell when those
text.
took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing
There's no record of it because Signal don't keep it, you
phone calls. You knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes,
Okay. And you never informed in your response that they were phone calls through signal as part of your communications, did you?
This is
again, because
amazing.
I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
There was no possible way
you've
to
read this court
physically
order,
give
haven't you?
the judge
Yes.
that record.
Did you
There's no
understand when the
possible
court
way.
was looking for all communications, it meant all communications?
And I provided everything that I have in my possession, sir.
During those 4 to 5 signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these signal communications happen before the
He already
asked and
this. He said
answered.
no.
He said from March this year. How can I know
He said-
this? You're standing in the room with the record, you fucking idiot.
end of the last
He
trial?
said specifically that in
No,
no way,
like I
shape,
said, they
or
were all
form did he
this year.
communicate.
You sure about that?
trial
Yes.
On that, on the
Now, at some
whatever
point,
it
did
is.
the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there
one.
wasn't a
She's gonna
contract, did you
slap-
receive a retainer agreement.
she's gonna slap Alan
No, I
Jackson.
don't believe so.
Yeah.
Yeah.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No,
Did you have any agreement that you were going to be compensated for your time?
no.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these conversations.
You're such an idiot. He gets paid by ARCCA. ARCCA bloods the bill. He doesn't get the money from the defense team. He works for ARCCA. Did
We've been
you
saying
pay
this-
Selbright to have your
Just
idiot
like-
ramble for 3 hours this morning?
Just like you don't give cash to your doctor, it goes to the billing manager of their office. Oh
That's
my
exactly
God.
right. That's a great metaphor, actually. That's perfect.
Conversations with the defense, and they asked you to come out here. Did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know.
Jesus,
So did you
Mary.
meet a person by the name of Kat?
Objection, Your Honor.
I'll allow it.
I think when I arrived here, yes.
Well, without qualification, the simple question is, you've met Kat, haven't you?
I think I met her, it was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Who escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Do you have conversations with anybody from the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
You just said,
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Objection, Your Honor.
I'll allow it.
It's a pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face, right?
Yes.
Yes?
Yes.
No,
Did you
he
have a
shook
conversation
hands
about
from
face?
behind his back.
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take a stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would need it. And I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there's kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds.
with Alan. Oh,
Stand
do you remember you just had a guy on who never ever talked to Jen McCabe, who put Jen's Selbright in his presentation. So being on a first name basis means that you are highly biased, Mr. Brennan. I don't know
called her
if
Jen.
yeah, I don't know the
Well,
amount
and we
of
left Higgins
cacti.
out.
Yeah. I don't know the amount of cacti in the New England area, but when this is done, please go frolic in a field of cacti. That's all I would say.
Or remove the one you already have inserted.
Yeah, there's no cactuses in
100 texts for logistics.
Massachusetts. They're all
Absolutely.
stuck in Brennan's ass.
I
right
can
now.
certainly go into the day before my trial testimony, which was a very extensive travel day where I don't think I left the Philadelphia
We're going
airport.
to get there. We're going to get there, but there's a lot more
Okay.
communications before we get even close to that. Okay. Do you remember
Oh,
on June
God.
10th having conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email
How do you
with
know?
Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
So everything from your mind was just logistic at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with a client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court.
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial,
This guy works for one of the biggest companies in that field in America. This guy was under a federal government gag order. And you think because he met his new friend Alan, he was going to say, hey, let's ruin my entire career and just let's chit-chat about this case. Alan, if you braid my hair, I'll braid your hair. Isn't it a great idea? And don't worry about money because I'm not going to ask for anything because I'm so biased and I'm just working for free. Oh, the retainer that my company sent you? Yeah, it's just my company. Yeah, of course I do a time schedule to make sure that my company gets money, but it doesn't matter. I'm just doing this for fun and let me and my company lose millions, if not billions, of future income because I can't keep my trap shut. I bet you this guy have seen more top secret stuff than most people. He worked for fucking
Guaranteed.
NASA.
Guaranteed.
Well, also, Brennan, this is not how friendship works. I know that you've never had one, but just because you go on Signal does not make you best friends. It means that maybe Mr. Jackson likes Signal. That's all it means. Just because you shake someone's hand doesn't mean you're besties. That just means you're a professional and not a dick.
We salute you, Mr. T-shirt launcher inventor. So simple anyone can operate it after a background check training course and 5-day waiting period. Have a cold Bud Light. We know you'll give Farrell the T-shirt off your back. Farrell, I've heard, would rather have no T-shirt on her back with Mr. Wolf around. Thank you, Brennan.
I to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk with Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
I hate this guy if no one had figured it out so far.
No, I'm getting on the hate train.
John, you emailed
I knew
right
you
now?
would, Mo.
Yes,
You know,
to Mr. Jackson.
okay. And what's it labeled as?
Wolf Direct.
And that's before you testified on trial 624.
It's at 6 p.m. the night before I testified. Yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. You recognize that one?
Yes.
What's that?
That is the attachment to the email.
You recognize reading that?
Yes.
You recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers that he asked you when you testified.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep.
Stop shaking your fucking head, you idiot. He's answering your question. I'm sorry, but at this point, Bev should call a recess, go back to her room, pound 5 White Claws, come back and say, you're out of my courtroom. You better
He is
show
not
up
even
tomorrow
paying
and try and
attention.
act like a lawyer, because this childish behavior, shaking your head at a guy who's just answering your question, I won't see that in my... Can we fly in, Judge Brandon?
Please.
You and I are going to get Judge Borowski right now. Yeah, I need to find some money and put in the swear jar as well, because fuck this idiot. Brandon, meet me in Newark. I'm getting a plane.
Be sure that you use Signal.
There's an email.
Yeah, and meet at the church.
Document like attached to this exhibit.
Okay.
Oh, geez.
Exhibit 1.
Mary and Joseph.
1.
So you assisted the defense before your testimony.
Hold on.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I said that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question,
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Oh, I hate him. I hate him so much.
That's it.
Oh, God.
Baker, can I say the word? Can I say the word?
Yes.
Or do I need to wait?
Well,
Fuck
I think
this
we all have
cunt
been paid more
sideways
than
with
we're
a
going to get in.
cactus.
Yeah, I think we've all been paid more in super chats than we're going to get in ad revenue for this shitty stream anyway. But fuck this guy.
Like, I have never been. He is not even. Look, I have a rule. If you are going to be a sassy and cunty man, you need to be flaming. And this man is not flaming enough to be this
He's pretty
catty.
close. He's pretty flaming.
He is pretty close. He's not Binger levels, which means that it is not allowable. On the flaming to catty, logarithm, it is just not there.
And the worst part, she's still going to do what this asshole wants.
Oh, yeah. Oh, yeah. And you notice he hasn't stopped making comments at all.
No.
If anything, he's picking up the pace on the comments, and she won't do shit about it. If that were Jackson or Unetti, or Alessi, she'd be all over him. Ugh.
Yes. And thank you, Jedi Jess.
Do you want to answer my question, or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor.
All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Objection,
He
Your Honor.
just did.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document, you said you just sent it because this is a standard thing. Why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You don't
question.
understand my question. I asked you about the outline, the direct examination you provided to the defense and you gave me a response that this is something typical, but it's just an outline, you wouldn't answer whether it would help the defense or not. But the reality is you weren't assisting the defense, isn't it?
Objection, Your
I'm
Honor.
going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they're going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony? for the defense,
Objection
you don't think
asked
that's
and
helping the
answered.
defense? No. Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What am
No, but your question is stupid because you don't listen to the answer.
I asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination. See,
Yes, slow down.
sorry, when you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I want to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone of the argumentation.
Did you write that?
Yes,
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. That's what I was trying to make sure that that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your
Okay,
question.
you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Did you notice that lady coming in, sticking her head through the door? She's probably thinking, do we have childcare in here today?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you
Answer
defer?
answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them, but the reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault. But in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you made a mistake? Wouldn't you want to inform the court? I stated qualifications I didn't have. It was unintentional, but it was a mistake.
Well, that's exactly why I put the comment in there, sir.
You put the comment. You didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to.
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
Thank you, Bev.
She's got everything she needs to side with them already. She's good.
Yeah, she's
Yeah.
she's
She
gonna
already
say
made up her
signal.
mind. So stop the circus. This has nothing to do with what's happening in court. He knows that Bev already made her ruling. He is doing this only for sound bites. He knows that
the
right
TV.
now, Court TV, Fox News, NBC, CNN doesn't cover it. Plevin, me, Mo, Aiden, we are all sitting here thinking, oh, that could be a good soundbite, and play that over and over again. Oh, you misrepresented to court is probably what Plevin is going to clip.
Okay, question. Bev is going to end this at 4. So, or are we going to go actually till 5 o'clock?
Well,
Because Brennan,
both of them coming through today, and she lost her mind because we've been going for an hour and 20 minutes now, and we have gotten fucking nowhere. They are there because they claim there was improper contact between the defense team and ARCCA. Right now, this massive C word of a beta male is yelling at a guy who can run circles around him just to try and get him to say something. He knows Bev is going to rule against them. So just get over it. You could just go up there and say, no questions, Your Honor. And she would still say, I won't allow it.
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial one,
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked in the court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed, at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. You remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCCA did send an invoice.
Then he wasn't paid by the defense, you fucking moron. Alone on this performance, Bev should stand up and say, well, fuck you, Brennan. I'm going to allow it even though I told you I wouldn't. Because you're such a you're such an idiot. Because paying someone 3 weeks after isn't paying them before. I don't know.
Yeah,
how do you get paid?
He's a salaried employee. He doesn't go after the people. He doesn't write down and bill. He doesn't have the coding. Oh my gosh, this is...
Afterwards, yes.
Did you talk to ARCCA about that? About the billing in this case?
No.
You submitted your bill? Yes.
ARCCA submitted the bill?
He doesn't submit any bills. ARCCA...
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics.
That is scheduling.
Yeah.
Do you want both of us? No, I think it'll be duplicitous. Yeah, it would be.
You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson. Not
I understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
But your report's not very clear who did what. Would you agree with me? The report's a demo report that has yours, Dr. Rentschler, and
Oh
Dr.
my
Klein's name
God.
on it. Would you agree with me?
He
All three of our names
answered
are on
the
it.
damn
Doesn't distinguish who
question.
did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easy to understand if you could just tell us what the conversation was. That's what I'm asking about.
Oh, fuck you, dude.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever
That's interesting. So the DOJ was watching the trial. Remember when Plevin said, it's over, there's nothing there?
communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And sir, is there any other communications that you've had with the defense that you didn't tell us about outside the text and the phone calls and the signal calls? Or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
Oh, I hate him.
I
I hate him so very much.
You not one questions relating to mythology, testing, the upcoming report that he wanted because he knows Bev isn't gonna allow it. Fuck
Methodology.
you.
Methodology.
Yeah, that's what I said.
Yeah. Santa has a for Brennan.
Oh,
Santa has a word. Don't be a dick. Santa Claus. Thank you. That is all. That is all.
I hate
Very
that I
good.
have to click all the time. It's so annoying that they changed it.
Are we going to get to Dr. Rentschler today or not?
Well, we know how much time is running.
I'm just asking you. Okay.
Wait, how dare
Yes.
she act like he needs to hurry the hell up
Yeah.
when Brennan asked
she wants to-
questions?
Yes.
She wants to give her ruling that she's had made up her mind already for.
Yeah, she
for
can just slip it over there and say, don't ask too many questions. Donation to the
Yeah.
swear jar. This guy makes me want to smash my phone into the wall. Well, if you do it fast enough, it'll count as running.
True. We're jumping.
Not jumping, yeah.
Dr. Wolf, I'm providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
all in your
Well,
possession.
it's I understand. So if Your Honor has it, I would like to be part of the hearing. That is exactly. Thank you. Thank you.
All that you possess is what's it's going to say. Any in
Yeah.
your possession, any communications you
I offer it
possess.
into evidence, Your Honor. May I allow the witness to have that?
Yes.
Thank you. Take it.
Oh!
You're with me, Your Honor? Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCCA had in our possession, we produced.
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCCA?
Well, let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have, from any time in 2024, any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
Let's now go to your first interactions with the defense. As I understand it,
Yeah.
Well, why don't you tell me what was the first date of your understanding of interactions with the defense?
I believe it was sometime in mid to end of March of 2024. Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness? Thank you. Your Honor, what I have is the entire production that ARCCA made. I think it would ease in terms of the.
Sure, he can have it.
Thank you. Use that pursuant to the subject matter permission to answer any of my questions if you need to.
Okay.
Now, in March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit here today, has there been any change whatsoever to that report?
No.
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice in February of 2024?
Yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony in the first trial, before you took the stand, did you have any discussions with any member of the defense about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCCA was working for the United States Department of Justice, do you know whether ARCCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
In 2024, Did the federal government prevent ARCCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you, starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
Okay.
Are you there, sir?
Yes, I think so.
Okay. Well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolf. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCCA would be compensated by the defense for any aspect of current or future work?
No.
Was there any understanding or discussion that ARCCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
Were you given a couch?
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that ARCCA would be compensated for any work associated with this case?
No, sir.
What was, briefly, the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to, I'm looking back at this phone record log, there was an incoming call to the ARCCA main line on March 20th, 2024 at 7 a.m. And that's Pacific Standard Time, so that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from ARCCA to Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes. I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense team about that invoice before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at ARCCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time and what your thought process is as you're entering each of those time entries? Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got an 8-9 hour day, right? I'm working on multiple cases that day, right? So I figure out, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet, so that ultimately, again, my boss and the accounting department knows what was Dr. Wolf doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying?
No, it fizzled out. He just yelled.
For this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall off the top of my head. I know it was the project number for the Department of Justice case, though.
Right, I'm sorry, I wasn't asking about the specific number,
Right.
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
And for any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to the emails we were talking about. Specifically, we left off with the March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email.
Right, Bush.
What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for the email that you're looking at? Sorry.
Tab 1, please.
Tab, okay. Right, so the first email that we were talking about on March 20th, 2024 from Mr. Jackson to myself, it looks like the next email was from me to Mr. Jackson. 2 days later, March 22nd, 2024 at 6 a.m., I sent an email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, I remember part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling logistics. And when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few there for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea, hey, can you come this day, right? And then I would relay that to Dr. Rensley, say, yeah, that works for me. So I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Now let's go to the next tab with regard to the outlines that you were asked on direct examination by Attorney Brennan. You've described this situation, well, you described how it is you view this situation. Have you ever been in this situation before where you're under contract with the federal government, there's rules of the road, so to speak, is what you can do, what you can't do, and then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that is my job.
Was there any other motivation that you had in sending that outline in that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we had this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours, in your mind, to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations. And I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
No, there's no reason for him to go to prison. It's just Brennan just lost his mind because he has a bad expert.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever?
It's voir dire of the expert witness from the first trial. Some call him Crash Daddy, some call him Honey Bunny, some call him, oh, you can do that twice. The rest of us call him Dr. Wolf. He is an accident reconstructionist, and not like some people on Twit thinks that because he is that, he knows how to signal encrypts their messages. But he's there for voir dire because Brennan claims that he and the Commonwealth had, not the Commonwealth, him and the defense had a shady connection. and it's been more than proven they didn't. But I still believe Bev will lose her mind and preclude them for rebuttal.
Have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
Did you recall any member of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony while during your trial testimony?
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? You remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
At the end of the trial, did you have any understanding whatsoever that ARCCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the record certainly reflects that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses, disbursements that you had or incurred up to and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed to December of 2024. Were there any conversations from the end of the trial until December of 2024, other than logistics? Was there any conversations of any kind? And please summarize briefly what they were, or text.
The only communication that I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time.
The Commonwealth wouldn't have had to pay them because they were retained by the defense, but they weren't because they were under contract with the Federal Bureau, not the Department of Justice, and the Department of Justice paid the bill. But then some low-paid accountant sent an invoice to the defense team, and the defense team said, instead of saying, hey, that's a mistake, Mary down in the billing said, yeah, it looks like a trial we're covering, so we're just going to pay it. And that's when everything blew up because Bev lost her freaking mind because she didn't understand what was given to her.
I'm traveling up here. I said it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Who's left?
Now let's go to this year. Did the defense approach ARCCA to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that.
Yeah, they had to reach out to DOJ to hear if they could even pay the bill because, again, they had no retainer with them. They were not allowed to because the DOJ had a contract with ARCCA. That's where everything blows up is because Bev is an idiot.
Time frame, I became aware that I think that there was a motion or two regarding ARCCA and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to...
Hey, Bev, did you hear that? Witness intimidation. You better get right on that. Tell all the fucking aunties to stop using this man's testimony in a case where he's hired by the DOJ to harass his wife and his kids. All these creepy fuckers on the other side who likes to sexualize kids. I hope the cacti farm in New England is getting a lot of frolicking today.
Sideways. Sideways, always sideways.
I did the math on it. It would be $6,000 a day per expert. They were there for 2 days each and got $6,000 per day. That's peanuts for these guys.
Figure out what's going on. Why is my family all over the internet? Why are they talking about me? Why am I getting all these hate emails?
Good.
So it was, I think, a conversation to figure out, hey, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCCA or myself.
So just so I'm clear on that, it was, you believe, regarding comments about ARCCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Ms. Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
And my understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the
They are only gonna he testified to this. We didn't change anything in our report since the first time. But Brennan is afraid because they're going to be used as rebuttal witness for his crash expert, who probably, if he's going to testify something with the spoiler, probably isn't going to do well on the stand on cross-examination.
No.
Well, especially when the medical examiner is going to say it was a contra coup, hit. So he hit the back of his head, which caused the swelling in the front. So Brennan, you suck so many balls.
Defense on signal.
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in...
They hired a new crest this time.
...utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, et cetera, do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, et cetera, did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Rentschler and myself are particularly interested in are extremely vague in that report and PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCCA's business to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time would it take?
Sadly, it won't work.
Well, certainly for the nature of this case, as I
made up her
mentioned,
mind.
we were officially retained by the defense on March 26, 2025. As I mentioned,
Yeah, she'll pick up
I
a
myself
written
just got word from
prepared
the Department
statement
of
and
Justice
read it.
just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward. He immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, at the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative terms, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So we immediately started to review that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right? So in a case like this, I mean, ideally, we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly we were on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from APTURE?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could along with Dr. Rentschler to review that material and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case?
Did you put other work aside at ARCCA to work on this matter?
Absolutely. Work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So
Congratulations, Dr. Wolf.
Okay, I'll move on, Your Honor. With regard to the work, you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
Correct.
You said you would like to have had more time, correct?
Correct. But I understood Your Honor's order and I wanted to meet that deadline. So I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline and we completed our testing.
And with regard to the testing now that you worked on that you just described, does that testing relate to any previous work or is it all in response to the new expert for the Commonwealth, APTURE, and the new information from APTURE that came in iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the ARCCA report and slides and scans?
No, I don't even know what we'd be responding to then.
So you needed the ARCCA information before you could even start working, correct?
Correct.
Do you have in mind, or does ARCCA have in mind, any further testing that you need to do, or have you completed what ARCCA needs to do with regard to fairly and properly responded to the new work of ARCCA?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we produced all of that raw test data, photographs, video, so it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, so that my next question, which is, there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long, on an expedited basis, well, let me ask, in the ordinary course, how long would it take you to do this last part of your work, in the ordinary course?
Probably, again, it could vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
That's all I have at this point, Your Honor.
Big screeners. Oh,
He really
just
is.
caught
He's
up.
amazing.
Yeah.
Oh dear God, not him again.
Did you ever read that signal report? Did you tell them, hey, we're going to F this weasel-looking mother effer up? Hey, isn't our guy the smartest guy you ever read a report from? Hey, what, if any, money did you get paid in a suitcase? Have you ever
mentioned
received...
in cross.
Yeah.
You mentioned in cross that you that you bypassed Alan Jackson in the hallway. Why didn't you disclose that on direct?
This idiot is going to ask the first thing he gets up there. So when you were sending the invoice to Alan, your friend, were you specifically billing him for like helping out the defense? And the guy's going to be like, Bev, the hell? I've told him I'm not even in invoicing. My TPS report goes to Phil, fills it invoicing, and then he sends it out.
Hey, just asking. When you bill Alan, does he come to your birthday party? Because if you don't mind, I have very few friends, and Chuck E. Cheese Wednesday, it's my birthday. So
he's going to go after the harassment claim. That's what he's going to do.
Yeah, I'll fix the harassment claim. I'll call my local harasser and tell her to stop. And then maybe you can meet me at Chuck E. Cheese. We could make.
You say you're harassed. You say you were harassed in this case. Are you aware that every other witness in the Commonwealth witness list has been harassed? So dumb. It's so dumb, y'all.
Are you in league with Turtle Boy too?
I'm confused. Can ARCCA testify? We don't know yet. Or is this what it will decide? Yes.
Yes. She's
technically, Signal is a protocol which also has an app using that protocol. WhatsApp and Messenger also have Signal protocol implemented. Zuckerman is a big fan of it. Yeah, but then he's a drug dealer. Because I just read the antis on Twitter, and if you use Signal, you are hiding something. And I said, no, the report didn't change. They are hiding things.
Just like using your Fifth Amendment privilege makes you guilty. When it very obviously
suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this
you
file
dumped
started?
800 gigs of data.
I think like a week or so ago.
You provided raw data last Friday?
Yes.
But you would agree you still have not provided any reports?
Correct.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand. Now, we're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th when you received authorization, and you're going to have things done by May 7th. So that's a month and a
Then
week.
need some aloe.
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know. No,
Did you know that it was turned over in a report on January 30th?
just the report.
Yes.
I didn't know that.
And
No.
the file in its entirety was turned over by February 5th. Did you know that?
Judge, Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing and report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCCA. Yes.
Putting aside the authorization, I'm going to ask you about that.
You can't put aside
You
the
can't put
authorization
aside-
because this is like saying, hey,
Baker.
did you win the Olympics because you ran a 100-meter dash a year before the Olympics? No, because
Okay.
the Olympics it's only every 4 years. But if you ran it the year before, could you have won the Olympics? No, because it's not the same thing.
You guys, the federal government, when it comes to like the DOJ and the FBI and stuff, it's set up fairly similar to the military. There's like rank and, chain of command, and authorization has to be granted before anybody can make any moves at all. Right.
Yes.
We may know as a soldier that we're going to deploy in a year's time for deployment, but there's a process that you have to go through in order to prepare for that deployment. You can't just all willy-nilly be like, okay, we're going to start training this now. It's got to come from somewhere else, somewhere higher.
Funny enough, when I deployed, we had a start date and an end date. And I didn't say, oh, cool, I'm going to be at the airport on the start date, because the Danish military made a decision that I had to go a month before everyone else because I was part of the transition team. That's why I have this nice back. So
Beautiful.
when everyone else jumped down in, I think, August, I sat down there in July. And when everyone went home and you had that 1 month period again where you think, oh, I was one of the early ones, I'm going to book my plane ticket home. The military said, nah, Baker, you're such a nice guy. Let's keep you a month longer, because that's kind of their decision. It wasn't something where I could potentially have been home a month before. My ex-wife didn't call me and say, hey, Fatso, I'm at the airport. Where are you? It's kind of something that you just wait for orders and go. You can't theoretically just go home. If Big Daddy government says you're not going anywhere, you stay. So if I had given you all the information in 2000, could you have done it before 2001? No, because I was not even in high school back then. So I didn't have the skills necessary. But theoretically, could you have done it? This is so stupid. It's, first of all, it would be rank speculation because he doesn't know what he could have done at that time. And two, he said it's all preference on what you want.
Yeah, well, not to mention, didn't they just got the entire file, the report, the completed thing from Aperture on February 5th. Now, they didn't get confirmation that they could actually work for the department, or they could actually work until, I think, February. Explain to me how Bev doesn't get this, because I can get this. I don't get cell phones, but my medium smartness, I get this. This makes sense.
I just no, I don't. No juror should at all listen to any of this, because that would be against every rule. But imagine being a juror and seeing this idiot yelling at this guy for saying, no, I was tied on my hand and feet, so I couldn't start doing the report because I had to have clearance from the government. you know, the government is kind of really annoying because they have all of this power. So if you break their rules, they can do a lot of bad things to you. Kind of like if you're lying under oath, you can go to prison. No one told Terry that. You can't just say, nah, fuck it, I'll do it. It's, again, you're going to get one paid job for this defense team and make, I don't know, $150,000, or you're going to come back and work on SpaceX.
Right.
How stupid is this guy? And how have Bev not stood up and said, no, this farce is over?
But just the time you need to test. If you knew or received the
She's
information
agreeing.
by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now. So wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True.
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal.
You can't do it without the timeline.
Jesus, Marion, you can't judge how long it's going to take you to test stuff if you don't have his stupid report. Baker, we are all getting this, right? How is...
Tomorrow I will be dressed like a cat girl. I will be in a kiddie pool, and I will just be laughing, saying, oh, if you super chat me, I'll write your name on my arm. That'll be my coverage tomorrow, because I can't do this anymore.
You heard him, Lesko.
This is going to be epic.
With this information, you said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCCA's did, in June of 2024, didn't it?
I believe it was sometime last year, yes.
Do you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
Did they turn over the report back in October, you fucking pillock?
No.
Are you aware of any effort by ARCCA or the defense to try to facilitate an agreement that the defense could use ARCCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use ARCCA, or specifically you and Dr. Rensselaer, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Rensselaer so you could review the materials?
Objection, Your Honor.
Do you know?
Because there's a gag order?
I don't know, no.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
One that comes to mind was,
Brennan's going to take on the
it would
feds
have been
now?
the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Oh, for
Is it a coincidence?
Jack's sake.
I presume so.
Well, when you were receiving information from the Department of Justice,
He's
about
claiming
witness
that he was
testimony in
leaking
this case,
DOJ. He's claiming that Dr. Wolf is leaking information from the DOJ to Alan Jackson. Are you out of your goddamn mind?
This is a federal crime you're accusing
Are
him
you
of.
out of your goddamn mind?
Brennan's taking
you're
on the
accusing him
feds.
of a federal crime under oath in a courtroom in Massachusetts. You are actually accusing Dr. Wolf of a federal crime.
I wonder if the DOJ is going to come in after this and just be like, fuck it, we're taking you all out. Like, look, in figuratively, not literally, to prison for being shenanigans, not.
I have a
What is
feeling if
going
they
on
did,
here?
there'd be a whole lot more phones disappearing tonight.
Let's.
This is a case, right, that's been going on for 2 years, and now this guy, because he's a fucking idiot, is accusing Dr. Wolf of breaking
a federal.
I'm afraid we're gonna. We might need to break our Friday rule. I don't know. This was cell phones and now federal crime felonies. I don't know.
I hope he called the DOJ to come in and say, did you know he's leaking classified information to the defense?
Yeah. I mean, it would seem like he's a mandated reporter if, he knows that there's, feds snitching.
I hope the DA's office is really in on this. No, Bev have already made up her mind. I'm just losing my mind over Brennan.
He's unbelievable. He's absolutely unbelievable. There's no shame in his game.
No, this guy, I know court we won't, but I hope every fucking reporter out there and every lawyer on YouTube and every lawyer who is willing to go on YouTube as guest will go out today and say, this is despicable behavior for a prosecutor.
Everyone except Caffey Daffy.
We've seen Binger, we've seen Krause, we've seen a lot of bad guys.
Gravely.
But seeing this asshole standing up and accusing a defense expert witness for breaking federal law, oh my God.
Unbelievable.
Was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No, it was just verbal communication.
And they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched.
Trooper Paul is
stupid. The kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that.
Nobody made you aware about a sequestration order in this case?
No.
He's an expert witness.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline of your comments. You recognize this?
Yes.
I'd like to introduce you guys in exhibit, please. Thank you.
I don't know who got the super chat.
This is great fodder for rage cleaning. Laundry and dishes are caught up. Going to start shampooing the rugs soon.
Holy Fazoli. I wish I had your talent.
I'm about to start scrubbing the ceilings.
So, as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
No, it was potential information from the DOJ, so they could have, hey, when this bumblenut is talking about this, we do have data that says different. Maybe.
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read. If you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when
Vicky we have our takes, they have their takes. I think most witnesses have come off as shady, but I am heavily biased.
Baby goat therapy. Thank you, Tammy Fayette. Thank you, Island, as well.
when an expert introduces new information, testing materials, it takes about, if not at least a month to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided the report, how many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions?
Classified. He just said it was classified.
Classified,
You can request it all you want, you
moron.
moron.
Jesus. Fake.
Well, Helen, do you remember back in the day when you were in the army now?
Mm-hmm.
Did you ever get a security clearance?
I sure did.
Do you remember that even though we like to tell tales, some of them a little tall, we always remember there's some things that we don't talk about.
Uh-huh. Even
because
you guys, even if you have the same security clearance, you can't exchange classified information. It's all it's literally a need to know basis, right? So if something's classified, what?
Even with the right handshake and everything, like
everything.
Dang.
If Baker and I both hold top secret clearances and we're working
I have
on
NATO
two
secret. Well, I used to have
separate
NATO secret.
Yeah, I don't think I don't think anything.
Well, I had to do it because I was doing a radio room and I didn't know shit about radios, but they said, yeah, you're cleared now. Don't I need a background check? Yeah, it'll be fine.
But even if we have the same clearance level and we're working on two separate projects, we can't tell each other about the projects. No. It doesn't matter. It's not like everybody with secret clearance can get access to all secret clearance material. That's not how it works.
No, it's on a need to know basis, and it's on specific. If you're working the radio room, you can get you will hear stuff there that might come in that you'll have to relay to someone. I can't then take the first guy and say, hey, Valhalla, can you run to the chief and tell him we're riding at dawn? I would have to go to the chief or make sure that the other one I pass it on to has the same security clearance, is allowed to be told about this. Did this guy ever anything?
Is Beth going to go to 5 o'clock?
Maybe.
Let's not get ahead of ourselves.
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstration, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
You never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one. So
okay.
no, I want you to focus on.
Okay, no, that was not produced. No.
You never turned over any
because
of that,
it was
those
classified.
Videos,
you
Again,
numpty.
we were not able to.
And was there any failed testing the first
We were
time?
not able to.
No.
In addition to videos, I'm sure you had other raw data.
He's an
notes,
idiot.
Photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided
Right.
in response to Dr. Welcher.
Okay,
Without
so
video
Baker, he's mad at the
and without the raw
feds.
data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round.
I don't think I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12
He's not confused. He's just an
no
idiot.
video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We
asking
have
you.
provided everything that he would need to evaluate the testing
Get
that
him,
we have
Dr.
done.
Wolf.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel with that.
That was weird. Watching all the lawyers stand up before she said anything. That was weird.
Well,
It's because
Probably
they have
walk
two
out.
different clocks on the cameras. So one of them is Unix time, so it's 2 weeks behind. So all of a sudden, we will see opening statements again on one camera, and the
Oh,
other
that's
camera
good.
will show us live feed.
That's good. That's funny.
The defense.
oh,
Is that Jay Leno?
he has a really Habsburgy jaw.
Oh my God, it's even worse than this.
Yeah,
It's
I noticed
totally
that
flat.
earlier.
Oh my!
He
He's
needs
probably a
some
genius.
beard.
Get a tan, my brother.
Let's bring Dr. Rentschler in here, please.
Thank you, Your Honor.
Okay.
Also, she's just gonna kick him out. Oh my God, this is worse than I thought.
Go ahead, Mr. Brennan. We
Thank
just
you.
need his name.
Good afternoon, doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler,
This should be interesting.
ANDREWJOHNRENTCHLER.
You've testified before in this case,
I have, yes, sir.
in a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
Okay. How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background. I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
I don't believe that ARC has any specific policy for that. No, sir.
Did you keep
Oh,
track
he
of
doesn't
your
realize
prior
Brennan's an
testimony?
asshole yet.
I did, yes.
And when you,
Oh, he
before you
probably
testified,
looked
did you
at
have
it.
conversations with people from the Department
No,
of
he
Justice
can't.
about this case?
Yes, I did.
Did they inform you about
He's
witness
going to figure it
testimony?
out pretty quick.
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean? Well, that certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were
Sure.
called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you
Okay.
information, even if you weren't requesting
Baker,
it,
can you
how fair
pause
did you
it?
file testimony, didn't you?
Is Brennan fishing for what the federal investigation into this particular office was looking for?
Let's just say for a guy who proudly proclaimed a month ago that the DOJ is done, he's very interested in knowing what the DOJ had and why they were looking at specific witnesses in the previous trial. That's all I gather from this is for someone who said they're gone. He's really interested to figuring out what the is they had.
I'm just proud I got one right today because I've been feeling mighty stupid. Look, I needed a win.
Yeah, it's a problem he didn't communicate, and it's a problem if you communicate. He's the typical asshole. Everything you do is wrong.
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order
Brennan being an asshole.
that there was supposed to be no discussion
Repeatedly.
of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, did you, before you testified,
If they didn't know there was a sequestration order, who's that on? Is there any lawyers in chat who informs an expert witness for the defense who the defense is not allowed to talk to because they are employed by the DOJ and there's a gag order put on them? Is it the defense who should tell them there's a sequestration order? Is it the court?
Oh, he's getting at yeah. Okay. I see what he's getting at now. That's dumb.
Yeah, and experts are not normally subject to sequestration.
No, especially
because they might be needed for rebuttal.
Especially if the Department of Justice hired them.
Yeah.
Just when I came to court, I think for the voir dire is the first time I met anybody.
did you spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and the family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not
So
going to be ready
after his
till May 7th,
testimony.
or after?
I believe currently that's what the estimated deadline is, yes.
And so when evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
And you
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do
And
that.
it's still not done.
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite it. Yeah.
All right. I appreciate that. Thank you very much.
Oh.
You're all set, sir.
Thank
So
you.
she's
All
allowing
right.
it.
Want to see counsel outside that for 1 minute?
She would. I can't imagine she wouldn't be able to allow them.
Yeah,
Like, I can't
think
imagine.
someone would get a call from the DOJ if
Yeah.
they tried to continue
So
forward with
if she
this.
allows it, I need to eat a dill pickle.
Yeah, you do.
Bev.
I've been
I
saying
think
all
Bev
along.
said-
Now that
I think Bev said, Brennan, you're an idiot.
Goodbye.
So no ruling. I don't need to eat dill pickle.
no ruling. Interesting. Interesting.
Yeah. No.
Interesting.
Yeah.
This was worse than I expected.
Yeah.
He
wait.
had absolutely no intention on doing what he claimed this voir dire was for. Maybe that's why she cut him off, because this voir dire was to figure out if they had unsolicited, not unsolicited, if they had communications with the defense team that they didn't disclose. That's what I was trying to say to the state, to the defense. And what we found out is, they talked to them, but it had nothing to do with anything. There was no favorism. Everything they were going to testify and are going to testify is either the same report that they already based their testimony on, or they are still working on. So they didn't fail to disclose their product because the product isn't done. They have now disclosed how much they have done. But again, this Commonwealth through 800 gigabytes. 800 gigabytes of material their way. And then and we know why, because they could just want to drown them and say, hey, they never answered. No, these are professionals. They will take every single little piece of everything and go through it. And we know from the motions filed against Dr. Welcher that his report is lacking a lot of explanation of how to, what to, when to. So they probably just sat there with 800 gigabytes of. So, yeah.
Yeah, well, not to mention the fact that if the Commonwealth had wanted this raw data, is there anything there were things precluding them, from getting the information, but so that was the same thing for the defense. The defense didn't have, the raw data. The Commonwealth was welcome to use ARCCA too. So this, well, what do you mean it was classified?
Yeah. Did you have any communications? Yeah. Was it classified? Yeah. What was it? I can't tell you. I'm just seeing if anyone knows anything.
That's unbelievable. Unbelievable. He can't get in trouble either because he's got protection for the questions he's asking, right? So he can accuse them of.
Yeah. He has said he can ask all the questions, and he didn't say, "So you're lying," or
right.
Tell me something.
Oh.
Doesn't look like there's anything out there about rulings.
Amanda took 32 gigabytes of pictures on the 18th, and it took 5 days to go through them and pick out which ones needed to edit for the bride.
JD.
800 gigabytes, a lot more. Like a lot more.
Yeah.
Yeah.
I have...
And no offense, but it's not just pictures either. It's actual information that needs to be processed and rebutted.
It's a lot of PDF files and test results, and you have to go back and do the math on them because we know the Commonwealth's experts probably isn't the bestest.
No, I know ARCCA, half of the communications were, what the hell are they trying to show in this report?
Yeah.
Do you have any effing clue what anything?
Yeah, that's what we know from Alessi. 800 gigabyte is the report and raw data from Dr. Welcher, who is the crash reconstructionist from the Commonwealth, who wrote a report and made a 144-page long PowerPoint that the defense said, "Hey, Bev, this is ridiculous. You can't bring in 144 pages of PowerPoint." And they said, "Okay, we'll go back and scale it back." So they scaled it back to 140 pages of PowerPoint. And then they said, "You'd be fucking kidding us." And half of it is not relevant. And we can't figure out how he reaches because he didn't provide us with anything. And now I think it's 44 pages long. He's going to be more annoying than the whiny guy we had this morning.
Ugh.
He was gross. That I have a mini fridge with White Claw in my office, and you better shut up right now. No sleep for the paralegals. Dr. Welcher. She's still going to sanction the defense. I'm pretty sure of it.
I think she wants to. I don't know if the testimony today is going to allow it because
I wonder.
ARCCA pretty much backed up everything Jackson said.
Well, I wonder how many people are going to get calls from the DOJ tonight.
Oh, there's going to be a couple.
Probably
a couple.
And yes, the rumor is that Jen McCabe will be testifying tomorrow. So sadly, I won't be sitting with my Newports and a Yingling on the Lanai in Tennessee. But I will be in my kiddie pool with my cat ear headphones on and say,
Bathwater on sale tomorrow at brokenbaker.com.
Yes, OnlyFans. You can go. The fart jaws jazz is only on OnlyFans. he has to resort to this before the proverbial hits the fan in the Turtle Boy case, and it starts to leak over to this case. I don't know. Turtle Boy is in court Wednesday, so, but it's a different case. It's a different case number, so they can keep it out for some time. But again, if they start to look into what they don't want is the judge in Turtle Boy's case to say, yeah, you can go frolic around in Jen McCabe, Meatball Morrissey's, Tully, Lally, Brennan, and Kerry's phones, because we have a suspicion that they could be colluding to do something bad to you, because that's when everything can come out.
That's what you call a conspiracy.
Yes.
That could be one of them things.
They've got like criminal charges for that and everything.
You can go to prison.
No, I distinctly
so.
have on my wheel of excuses. I didn't know it was a crime.
Conspiracy to intimidate witnesses. Yeah, I'm sure they've put Hell's Angels in prison for that before.
Yeah. If you think you can't have a 150-page PowerPoint, you have never done American military education and training.
That is true.
We didn't do much. Well, I might have done service before PowerPoint really was a thing. But to this day, I can still remember our How to Survive in the Cold training, because it was the worst 70s movie ever. And it was,
no.
Did you know hypothermia is a silent killer? So if you are out hiking and you suddenly start to feel warm and feel the need to take your shirt off, you might be experiencing hypothermia. Make sure to alert your buddies, or if you're on a trail with others, make sure they are with you, because you just want to lay down and fall asleep. Cold can kill. Did you know that if you are out sailing and falls in the water, even though you are dressed appropriately, water will suck the heat from your body and you will fall asleep and die? Cold can kill. It's
shit.
Yeah. Please leave your last message. Then I'll have to go back and find it. I hope Brennan has a good pension fund, because I wouldn't hire him to do my next divorce. What a C-word slimeball. Timberman, I agree. But again, he's getting a golden parachute out of this, because so far, 275,000.
He's quickly approaching that 300K mark.
He's almost getting paid as much as a police officer in Massachusetts.
That's true. That's true. Oh my God.
So do we think that Bev is going to require a longer voir dire?
No, this was the voir dire. He got fed up with him and said, shut up, and we're going home.
Oh, okay.
Yeah.
Because I was wondering, I mean, oh.
You know that's his O face, right?
Oh.
And I can absolutely not and would never insinuate, but I bet you he has a black leather couch in his office for new paralegals.
Uh-huh.
Oh.
You know it's true, Mo. You know it's true.
Oh, I just didn't want to think about it. True or not, there's like things like you just assumed that your parents adopted you and your siblings once you learned about how children were made, because your parents don't do that.
And Krista, we will never find out what happened at sidebars unless someone is really stupid and writes it on Twitter, and then will be yeeted out of court and probably also be in criminal trouble, because sidebars are secret and there's a sequestration order on the court that no one is allowed to share it.
You're welcome, chat. You're welcome.
Looks like a British claymation. typing with one hand when Jen's on the stand. No, I will be.
You know, he could be on Shaun the Sheep.
I don't know what that is.
Shaun the Sheep.
You know, the little claymation with like the farmer guy, and he always has the little sheep
Oh.
with, the, you know, like the chicken run. And
Yeah. I didn't know that had a name.
well, I thought maybe I made that up, to be honest with you.
I'm sure it has a name. I have no idea what it is.
I'm just saying that my kids have kids, so I'm too old for knowing any of that.
Relevant pop culture with children stuff.
Yeah. No one was yeeted. There was a discussion with a juror, but no one was yeeted, and no one will know, and you'll probably find 5 different channels speculating that it's because they did something. But until we hear it, no one knows. And if anyone who was in court talks about it, they break the rules. Yeah. They could, and then they'll be kicked out of the jury. They are still on the jury. But it's almost 5 o'clock.
I knew she wasn't going all the way to 5.
No, you haven't got your mug because I haven't sent it yet. It's right here behind me. I have been a little busy with the first week of this, so sadly, they have kind of taken the back pedal. I will send it as soon as I get a little more, because I do these 8 hours of trial, and then I have to go set up the streams for tomorrow. Then I have to do recap videos, and then I have to try and have a live. So I'm a bad giveaway.
Text us to remind us to delete tabs.
Well, then that juror should be thrown off the jury and never be allowed back in the courtroom.
That's funny.
It
always
will
listen
be
to
there,
Santa.
Carl. When I mail stuff out, I'll put it in the community tab and just say, hey, I did something good today. I didn't just spend my morning. This morning, I spent my morning doing stupid stuff because I'm stupid. I don't know if anyone had found out.
I love that I just had a great idea for the puppet now that I thought about Shaun the Sheep, because he does look like all the evil people in Chicken Run. The evil chicken lady.
Totally on me. This is what I spent my morning doing. Yes, I am that. Yesterday I spent my day writing a 40-page children book. Why? Why didn't I just print out 6 labels and get this shipped? Because I am a lazy fuck.
Well, I mean, you didn't work on Lawyer on the Stick, you know. Now, it's my first try. I know. Well, that gave me the idea. Wallace and Gromit, I can totally do the claymation look because he looks like the evil chicken lady if she were a dude.
Terrible.
I think it's a word in Dutch.
I don't think it's in English.
No, I know it's Dutch.
Not from what I
Russian
remember. Is that English?
It's Dutch.
Oh, I am having a stroke. Damn it.
Thank you, Edward.
And check.
Yeah, that's me. I love that my procrastination for not sending out 6 packages is writing 40 pages of a book. Because I'm
Steve
just
Gosney could have got that knocked out. Steve Gosney could have got that knocked out in about 5 minutes, Baker. Be better. Be better.
Yeah, I know. So this whole hearing was pointless. No, it wasn't, because we'll still need to hear on what we heard, because remember what this hearing was about, that there was some nefarious communications going on between ARCCA and the defense. We now know, based on ARCCA's testimony, they don't have anything to share with them, and everything that was going on was planning. It was
Completely
nothing.
by the
It was a
book.
big old nothing burger. Well,
Yeah.
Did you give him your parameters for payment? Yeah. Brennan, when you talked to Meatball Morrissey, did you say, I'll just start. We can figure out the payment later. Minimum wage is fine. Or did you say, if I'm going to do this, I'm going to have at least a new house at the Cape when we're done? I have been farting a lot.
That explains a lot.
Well, it could be either way. Could go either way, I guess.
Yeah, I
don't
love
think
that
Kid
it's
Rock could grow a
classified
beard.
because, and then I loved his next question. So, but what did you give them? It's fucking classified, you idiot.
I can't tell you, dummy.
Thank you, Tom,
Well,
and congratulations,
thanks, Tom.
Tom crossed at 10,000 subscribers on his YouTube
Awesome
channel today.
sauce.
Hell yeah.
If any
That
of you
is
are golf
great.
players, golfiets as they are called, and you like to learn how to swing a bat, go check out Tom Gillis. He used to be a pro
Are they
golfer,
bats or clubs?
and
Think-
Brandon is always talking about swinging meat bats. So I thought that's what you call a golf bat. But if you want to learn how to swing your bat, go follow Tom Gillis. He is really good at hitting it out of the park, almost a home run on every swing.
You almost nailed every sport metaphor in there. You almost got it. You need like a touchdown or a field goal or a punt or something.
No, because that's
What about a sidekick?
no, that's karate.
Wait, then what do you do in soccer when the guy kicks it from the side of the field? What's that called?
You think about a throw-in?
I don't know. I thought they weren't allowed to touch it with their hands.
When they throw it in, they can, and the goalie can.
Yeah. Maybe
God,
Brennan
now I
should
have to
take a
watch
hint once you
sports.
start poking into classified material for your stupid contrived hit and run case. Exactly. And again, as I said, I think I was to Brandon this morning, this is a stupid hit and run case. It should be a week, and we shouldn't be talking about all the people who were in the house, because they should just say, yeah, we thought they were coming over, but they never came, and it was kind of weird, but yeah, we were drunk and having a party, and fuck if I know what happened. I was texting him, here, if you come park behind me. I was drunk, so my text looks a bit weird. None of this should have been, this should be 1 week of testimony. He has these injuries, she has that damage to her car. That proves it. But
When the
this
Commonwealth
is again turning into Jen McCabe didn't do it case.
That's exactly what I was going to say. When the Commonwealth spends most of their case in chief defending their own witnesses rather than providing evidence of guilt, you know it's messed up. You know it is.
I will be interested to see how the pro people cover Mr. Doofus from England this morning.
Witten. No, Witten is that's someone else.
Whiffin. That's it.
Yeah.
Whiffin.
You know
Okay.
who Witten is.
The tight end.
No, the one who was on Cecil's show.
I
You
don't
know
think so.
Cecil.
Yeah.
Roughly a year and a half back, he did a fundraiser to help out a girl named Witten to
Oh,
get her started as an independent contractor in a business.
how'd that go?
Well, she disappeared after they found the money. She might have had
That
a
sounds.
small
Haven't heard
problem.
from her. No idea.
Yeah. But yeah, I think she's on some of Cecil's. We know weird people on the internet, even though we don't know them really.
I will be interested to see what they make of his testimony, because I can tell you, as someone who really attempted, I mean, I have 13 pages of notes. I've got 6 pages of notes from Cell Phone Man. I understand not one GD thing he said. So
I think I figured out most of his testimony was just circle talk to not.
I know, but I
represent the
understood
truth.
your explanations better than his.
Oh, well, thank you.
You're smart. You should be an expert.
Sometimes I have my moments. Who doesn't know Cecil?
Well,
Ooh.
Aiden should sometimes pipe down a little bit. I think right now Bradel and Bettero are thinking, fuck. But, yeah.
Damn it.
Fedorowski, not everyone goes into the depths of the internet that you. Sometimes I'm in chat and I see, oh, that's Fedorowski.
I've met Cecil. He's awesome. And we got along really well. He's a good dude.
I think you would.
Yeah, he's fun.
Whatever you do, don't go on Twitter. You'll just get angry at a whole lot of stupid on there. I'm glad I'm going to bed.
Oh, yeah.
Thank you so much, Baker, Mo, Valhalla, Mods, and chat. See you tomorrow. Don't be so naughty, Pimpernella. Well, Pimpernella is, I think she's from Belgium. Belgian people is a little, again, it's an invented country that didn't exist 150 years ago. Well, 200 years ago.
They got awesome waffles, and that's all that matters.
True.
Yes, I did see neighbor Jim who was, and they made fun of him because he only had one glass. He had eye surgery, so he needs to have one glass in his glasses, and all the aunties were, oh, this idiot. He knew them, and either he or someone in his family had been attacked by Chloe as well. Hey, 80s.
Hey, 80s.
Baker is a very smart man. Oh, no, I'm not. I'm good at retaining information, but I'm not that smart.
You are exceptional at retaining information.
Yes.
It's
and
almost annoying. It's almost annoying.
Because I'm over here like, that guy with the name, he was there, he had a face. Come on, Baker. Work with me here.
Jesus.
The only thing I can't remember is the guy who drove Ryan Nagel.
I want to say
he's got an Italian name. It's super Italian. DiCuccio?
Belgium has a racetrack with one good series of corners. Is it Spa? Isn't that in Belgium? I think no. Next week they're racing Miami. Where's Formula One next week? It's Miami. I love Jim. His friends visiting Jim was attacked by Chloe.
That's what it was. Dantano. Camper for Life nailed it.
D'Antonio.
Dantano is how they say it.
Yeah, that's not Dantano.
But that, she got close enough. She got me there. That's all that matters.
It is Miami. Oh, cool. Unfortunately, that racetrack is in the Croissant part of Belgium. So that's Flanders, right?
Who are you asking?
For The Simpsons? Or...
I can almost assure you.
Flanders is a part of Belgium that's French,
well then...
and then because Belgium is it came out of the Napoleonic Wars when they had to divide it after Napoleon got defeated at Waterloo. Waterloo couldn't resist if I wanted to.
That was actually our history class. That's why we don't know what you're talking about.
But then to kind of make sure that they kind of had that buffer zone between France and Germany and stuff like that, they made Belgium. So it's part French, it's part Dutch.
Oh, so I wasn't completely
all kind of weird. They eat moule frite and make the monks brew beer, and that's pretty effing good beer. It's called Trappist beer. And it's really good. And I like it. I think it has to be at least 10%, but the Lord always give a little extra.
Makes sense.
Wasn't that from the Kevin Costner Robin Hood? Friar Tuck said something along those lines.
No, but that is actually what the reason is, that it has to be at least, but the good Lord always provide a little extra. You're older than the Dutch. No, you're not. Holland go way back. They just changed the name. Isn't it Flanders? So it's the other one. I can't remember what. I don't know everything. I know Belgium is two countries and they're kind of weird against each other. They don't like each other. But we have a lot of that in Europe. Oh, you live there? I hate you. We have an island just south of where I'm living. There's a line on the middle of the island. If you are born north of it, you won't go to the southern part. If you're born south of it, you don't go. And normally they used to have two ferries going to that island. Then they canceled one of them. So everyone from the south has to go to the north if they want to sail to the mainland. There was actually people
that's
going
bad?
out. People went
Let me
out,
tell
bought a boat and an extra car to leave over here, so they didn't have to take the ferry.
That's insane.
No,
You think
But I
that's
guess you
bad?
did-
Wait till I tell you about this place called the Gaza Strip. They're real.
well, they have
Well,
only been
you
hating
know.
each other for the last 80 years. This
They've
one goes
had some
back.
history.
Oh shit!
I thought it was horse racing. What? Ooh. Europe is old. Yeah, America. Psh, I have shorts older than America.
Fair.
Yeah, it's 2 countries and Brussels. Yeah, that's how it is.
Yeah, Brussels has only been around since like the 90s, right?
It's a rough place. The Netherlands in its current form is surprisingly young. Pimpernella is right. Only North and West Holland provinces considered Netherlands back then.
Ah.
Penella, I won't stand hate crimes on my channel. Who has the best chocolate? The Swiss. But I think that is all you're going to get for that quarter. As isn't that what? But that's all, folks. And I think in Denmark, that's all you get for that 25 Danish.
Porky pig.
But that's Ostende. We've been here much longer. I don't. It's a weird place. I'm Dutch. Isn't it weird, y'all? Maybe I've seen too much Austin Powers to really.
Oh, well.
In 7th grade, we went sailing, and they have a lot of canals in Holland, and we went sailing on them and on the Zuiderzee. And we had one chick in the class who got seasick, and she puked behind a bulkhead door and didn't tell anyone, so the entire boat smelled like it.
Oh.
That's just not okay.
No.
Why wouldn't you just puke off the side of the boat?
Because she was kind of weird.
I thought you people were like sailors. I thought you were supposed to be around boats like your whole life.
She actually had a lot of sailing in her because she was a Vietnamese boat refugee, so she's been sailing before.
Oh, my bad.
I shouldn't be laughing.
No.
You can laugh. It's funny.
But I'm
What's up,
continuing
Orc?
to.
What's up, buddy? How you doing?
Don't forget to vote for. Oh,
If
in
you're
Canada,
Canadian.
I think.
Yeah.
Yes.
Yeah, if you are in Canada, remember, if you don't use your power to vote, you'll lose it at some point. And if you don't vote, you don't get to complain of all the bad stuff they do until the next election. That's what I always told my kids, because they said, do we have to vote for the party you're in? And I said, nope, but you can't complain if you don't vote.
True.
I'm really kind of surprised she didn't make any rulings at the end there.
Because I think that it went way worse than she thought.
Oh yeah. I don't think she understood exactly what was going on. And then when he started knocking on the Department of Justice's door,
yeah, I don't think
didn't
she
want no part of
expected
that.
Brennan to bring any Fedness into this.
Yeah. But that's how it is. I'm going to get out of here because it's getting close to 11 o'clock. I'm going to do all the things and all the things. You please go do all the things as well. So we can share the love, because I'm all out of love. I'm so lost without you. Got an arc on my mind, and I want to know what DOJ said. Can I be a friend if I sell you a building? Brennan's a cunt.
It's cut and dry. Pretty simple. Just pin it on the girl, right? Pretty simple. Just pin it on the girl, right?
Objection.
Pretty simple. Just pin it on the girl, right?